While this episode of Life, Loss and Legacy is meant to help you learn and educate yourself around some of the topics discussed, it is worth noting that all opinions and information provided are the opinions of the individual speaker and do not represent the opinions or thoughts or perspectives of any other party. I also want to emphasise that the information contained in here is very general in nature, and it is vitally important that before you make any decisions about what to do in your current estate situation or following that, be sure to obtain personal professional advice. We do not know your current circumstances, so please do not act based on what we talk about in this episode. Be sure to get that extra advice. All right, that's enough warnings. Let's get into the episode. Thank you very much. Hello and welcome back to another episode of Life, Loss and Legacy, a podcast series by Planning Solo to help people that are going through bereavement navigate those first few years after the loss. My name's Vaka. I'm an independent financial planner with Planning Solo, and we specialise in helping people walk this very path. So the idea of this series is to bring experts in to answer some of the very particular and very specific questions that we get asked on a regular basis that, frankly, I don't have the answers to. So I'm very excited today to say that I am joined by a special guest, Claire Stollery. Claire, thanks for joining me.
Thanks, Jordan. Thanks for having me.
Now, Claire holds a Bachelor of Laws with Honours and a Bachelor of Arts from Monash University. She has a graduate diploma. I'll start that again. A graduate diploma of legal practice from Leo Cusson Centre for Law. And she is a partner at Tony Kelly Lawyer and Estate Planning. Claire relishes the challenges that this dynamic area of law can bring. Her areas of expertise include discretionary testamentary trust structures, probate applications, and powers of attorney. And I'm particularly excited to have Claire join me today to talk about testamentary trusts, what they are, who they can help, and also the on-the-ground reality of actually using a testamentary trust. So Claire, again, thank you for joining us. Can you talk a little bit about, I guess, the work you're doing in the estate planning space for people?
Yeah, absolutely. We work with clients from a range of different backgrounds, but our specialty is people sort of complex or different needs in terms of their estate planning. So particularly people who have either a large asset pool or different types of trust structures, business structures, something that just needs a bit of a bespoke approach as opposed to just a will kit sort of formula approach. So we are looking to help people get that really smooth transition from one generation to the next and ensuring that their assets are protected for the future generations to come.
And I think that smooth transition point is so important and not as common as I think we all wish it were. So some of the people listening to this may be going through one that isn't quite as smooth, but buried in there is that testamentary trust that they've got or that they're now having to take care of. So we'll be talking about three different areas in today's episode. The first one is a background on what a testamentary trust actually is and why people use them. The second area we'll walk into will be an overview of what actually happens when somebody dies and how that trust comes into existence, because it doesn't exist until that point. And then finally, what I'm most interested in covering are those real life mechanics of actually running a testamentary trust, because there can be a little bit of complexity in that. And if, like most of our listeners, you haven't really been super involved in the financial side of things, it can be a little bit complicated. So, Claire, I'm going to throw some questions at you and we'll see how we go through them. But the first one I'd really like to explore is pretty fundamental. What is a testamentary trust?
Yeah, of course. So it's sort of breaking it down into two sections. So the word testamentary simply means something that's created in a will. So a testamentary trust is a trust created in a will, but then we go to, well, what is a trust? So the main feature of a trust is that rather than someone holding an asset in their own name, absolutely, it's theirs, they do what they want with it, they own it, that's it. We have a situation where we have a person or a group of people who own the legal title to their assets or a pool of assets. So that means their name's on the certificate of title of a property or their name's on the bank account, but they're not holding it for themselves, they're holding it for the benefit of a group of people or another person. Sometimes it's easy to think about, when you think about testamentary trusts, it's easier to think about sort of what they're not. So a classic will would be, I leave my estate in 3 shares to each of my 3 children. And when everything's said and done, each child walks away with their own pot and that's it. a testamentary trust sort of creates more of an ongoing relationship between your trustee, so the person holding the assets, and the beneficiary or beneficiaries, who are the ones who will eventually receive benefit from those assets, but they don't hold them in their own name.
And I think, again, if you're not very experienced in this area of finances, that trust concept can be quite hard to get your head around, because it is kind of when you think about it, it's quite an odd structure, but it's very commonly used, and it's used for very good reasons. And we'll come back to kind of why people use trusts, particularly testamentary trusts. But if we could also just maybe define sort of who's who in the zoo here a little bit. Can you tell me who the will maker is? It sounds like a silly question, but who the will maker would be?
Yeah, I mean, it's what it says on the tin. It's the person who has written the will. And in this case, when we're talking about testamentary trusts, the will is the instrument that creates the trust. So the will maker is the person who sat down with their lawyer, had to think about what they want to happen with their assets, and then put pen to paper.
And then within the will, there'll be an executor nominated. Where does the executor fit in?
Yeah, so the executor is the person responsible for the initial administration of the estate. So when someone dies, they're the person who is responsible for obtaining a grant of probate. So that means going to the court saying, here's the will, here's the death certificate, here's what the person owned. And the court gives you the stamp to be able to go ahead and deal with that person's assets. The executor is really the person that stands in the shoes of the deceased, and they're carrying out things like closing bank accounts, paying off any debts, closing your electricity bill. If there's property that needs to be sold, they're the ones selling the property. And then once all those assets are called in and the debts are paid out, they're the ones that are distributing the estate into the next stage. So either making bequests to people, for example, there might be a $10,000 gift to a charity, they're the ones sending out the check, or they're the ones that then pass over to the next stage, the trust stage, when we're talking about a testamentary trust.
It's not a small job. I think maybe traditionally people have seen it as kind of a glib thing, but it seems we're doing a whole episode on it because it is such a significant role. So they're the ones that are, I like that phrase, standing in the shoes of the will maker or the deceased. Then the beneficiary, how do they fit into the picture?
Yeah, so the beneficiary is the person who is receiving some sort of benefit or entitlement under a will. So we can have people who receive an absolute bequest, so again, a gift of $10,000, which can be paid by a cheque or a direct deposit. But when we're talking about a testamentary trust, they're the people who are receiving the benefit of the assets. So that can be distributions of capital, that can be distributions of income. We'll get into that, I think, a little bit more later, but they're the ones who are receiving the benefit. And
just to complicate things further, there's a vaguely different kind of outline for who can be a beneficiary through a super, but we'll leave that for another episode as well. And then we've got the trustee. So I think you've talked a little bit about where they fit, but can you also expand maybe on the differences between the trustee and the executor? Because I think there's a lot of confusion around that.
Yeah, and it can be confusing, especially because sometimes they are the same, often they are the same people. But it's sort of two stages in a process. So the executor is performing those jobs we said before about administering the estate, selling assets, paying off debts, those sort of tasks. The trustee has an ongoing role as the person who holds the title to the trusts. So when we get to the end stage of that estate administration, everything's paid in, we're all ready to sort of go, that's when the roles transition. And the trustee is the one who's holding those assets in a bank account or in their names, and they're responsible for the next however many years for looking after those assets and making distributions to beneficiaries. So they are the same person as the executor, and it's just that the roles sort of roll over, but sometimes they're not. We might have a situation where executors do all that initial administration, and then we have a number of trusts and each has their own trustee. But again, it's just that ongoing role of responsibility for those assets and looking after the beneficiaries.
And so if you are both, this is kind of ad-libbing this bit, but if you are both the executor and the trustee, your roles are slightly different, aren't they? Because as the executor, your responsibility is to stand in for the deceased. But as trustee, your responsibility is to act in service of the beneficiaries.
Yeah, absolutely. So most of the time it is a fairly smooth sort of process, but you do sort of have to think about changing those hats a little bit. That when initially in the first however many months after the person has died, that's when you're really wearing that executor hat, and it's all about administration of those assets. Then you sort of start to put on your trustee hat in the long term to think about beneficiaries.
I like that, the hat distinction. I think it's a good one, particularly for our audience. It's that idea of you are moving into a slightly different role, similar responsibilities. I'm aware a little bit about other trusts, and I know that the appointor is a very important role in other trusts. Is that applicable in testamentary trusts?
It is. It's probably something we don't sort of enunciate as much in the will, but it does exist. So the appointor is the person with the power to appoint or remove a trustee. So when we're talking about other types of trusts, that's a really powerful sort of role, because if you're the appointor, you sort of have the ultimate control. In discretionary testamentary trusts, sometimes we'll find that the will does specify someone to be an appointor, but often the trustee and the appointor are the same person, and the trustee will have the power to remove themselves down the line. I mean, a trust can last for 80 years since it's created, and that includes a trust in the will. So someone you appoint as a trustee in 2024 probably won't want to be a trustee in 2104, so 2104. So they do have that power to step down, usually at some point, and appoint someone else to take over.
And I'm assuming here that if they do want to be trustee, but maybe the beneficiaries don't want them to be anymore, can they be removed?
It would depend on the terms of the deed and the terms of the will. Generally, beneficiaries, I would say, can't just team up and remove a trustee, but we can talk a bit about later when we can talk about things that go wrong, there might be an opportunity there to go to the court to remove them. But generally, no, and usually a trustee has sort of been put in place for a reason, and sometimes willmaker may anticipate a situation where there's a bit of hostility between the trustees and the beneficiaries, but that's sort of the reasoning why they put that person in place.
And I think in estates, that's one of the most fascinating things to me, is the perspective you need to have as a practitioner, that you're kind of looking at these branching realities and possibilities over a very long time frame that you then need to document. And I noticed you said kind of the estate lawyer's mantra, it depends on what the deed says and it depends on what the will says. It's very much, you need to be very familiar with those documents as trustee and executor of what they actually say.
Yeah, absolutely. And it is really difficult to forecast, and that's something that we find when people come in to talk about their wills and talk about these testamentary trusts. We're trying to safeguard things as much as possible for the future, but you really don't know how things are going to go. We try to approach it with the mantra of what would have happened if you died yesterday, sort of thinking about the immediate realities. But at the same time, when we're drafting a will with a discretionary testamentary trust, we're really looking at clauses that have some flexibility for the long term, so they can adapt to the changing needs of the beneficiaries and the trustees in future.
That makes total sense. And I think the last role I'd just like to expand on a little bit and how it interacts with testamentary trusts are guardians for children. How do they fit into the picture?
Yeah, absolutely. So if you've got kids who are under the age of 18, your will should appoint someone to be their guardian in the event that both parents were to die. Some people choose to have the trustee and the guardian as the same person. So, for example, there's a family with 2 kids who are aged 3 and 5. The will sets up a trust for the benefit of those children. When both parents have died, all their assets are going to be on this trust for the benefit of the children. Separately, there's another clause in the will that says, I appoint my brother Steve to be the guardian of my children if something happens to me. If Steve was also the trustee of that trust for the children, generally, he would be able to advance money to himself out of the trust to look after the kids. Sometimes people then say, okay, I want a bit more oversight, or I've got people in my life who are good at different things. I really want my brother Steve to look after the kids. He's got kids of his own, he's great with kids, but my sister Fiona is an accountant. I know she'll be really great with the money. And so generally we would draft the will. Again, all sort of depends on the drafting, but saying my trustee Fiona has the power to advance sums out of the trust for my kids to the guardian, Steve, so he can pay for their day-to-day expenses. We might also have other powers in there. There might be a residential property in the trust, and we say, okay, Steve can live in the residential property in the trust with my kids to look after them. So it can be a little bit complicated. We do also find that the choice of appointing a guardian for children is difficult, it's emotional, and that whole decision about whether you appoint someone different or the same person it is really hard. But they do, ideally, we want people who are going to interact with each other well, because they are going to have that ongoing relationship while the kids are under 18 to be able to advance funds for the children's benefit.
Yeah, I think it can tend to be a bit of a roadblock for some people, prevents them getting it
Absolutely.
even drafted because they can't agree. Well, thank you. I mean, it's good to know kind of the different roles, because we use this terminology easily and frequently, but for people going through it, it can be a little bit of a new language. But I'm keen to move on to the testamentary trust piece now. Now, not every will has a testamentary trust. So I'm curious to hear your thoughts on who do you think, or who uses testamentary trusts in your experience, and who do you think should use them?
Yeah, so I think sometimes when people sort of hear the word trusts, they think it's something for, the super wealthy. They think it's all sort of something that billionaires have. But in reality, a testamentary trust is a great vehicle for anyone who wants to protect a sum of capital for the long term. It may be, you think, well, I haven't got that many assets, but if you have a house, if you're a couple and you've got a house that's paid off, a house in Melbourne these days, the average price is $1 million. You've got nearly. If you've got 2 kids, that's $500,000 each. It's not an insubstantial sum, and you might want to think about how that can be best protected for them. So talking about sort of ongoing asset protection, it's not necessarily about ruling from the grave. I think some people are concerned that they're really locking up assets in future, but that's not the reasons we do it. We're sort of looking at how to keep things going for as many generations as possible, and allowing your children and your grandchildren to have the benefit of what you've accumulated during your lifetime. And they're especially important where you've got a situation where there's any sort of risk for your children. So, for example, if one of your kids, it's not just for children as well, but that's sort of the more typical scenario. But if one of your children is someone who owns their own business, or they're in an industry like, for example, construction, where they could be sued down the track for something that went wrong.
Or law or financial advice or something.
Yes,
silly.
Absolutely. If you've got that trust, that's sort of a separate entity. It's not something, any assets in there are not assets they own personally, so they're better protected against creditors when things go wrong in their business. Similarly, we do get clients who are concerned about children's spouses. They feel that the relationship's rocky, or maybe that their child's partner is not a great financial manager. And if you had left a bequest to that child outright, they'd probably put it on their mortgage. It would get scrambled up with all the marital assets. And then if something goes wrong in the relationship, those assets, that inheritance is lost quite easily. Having it in a trust means it's more secure. We can put extra sort of protections in to exclude that spouse from having access to it. And again, just protecting things for the future. And then probably another situation we do have is where the beneficiary themselves sort of needs protection from themselves. So again, might not be a good money manager, might be someone who has addiction issues, and we want to make sure that there's someone supervising the use of that money and making sure it's properly applied to them in the long term for their ongoing benefit.
And I think that protective mechanism is something that maybe isn't always passed down to the trustee or executor for the people that we speak with. They kind of get lumped with this thing, and they don't always know why it's been put in place. And I think there are really powerful reasons to use one. I mean, from our side of the pond, there's taxation benefits that come with having assets within there, and that idea of not owning the asset but still receiving the benefit is really powerful. Can you maybe walk us through kind of the people leaving the guardianship to Steve and the financial side to Fiona? How would a testamentary trust work in that case, where you've got mum and dad, 2 kids? What's a common structure you'd look at using for that?
Yeah, absolutely. So something that we like to do is, rather than saying mum and dad leave everything to each other, and when we're both died, we'll make a testamentary trust. We like to have the surviving spouse and the kids all in one trust. So let's say mum's name's Amy and dad's name's Ben. Amy's will would say, I leave my estate on trust for the benefit of Ben and my 2 children. Ben would be the trustee of that trust, so he still gets to look after the assets. But when any money from that trust is invested and there's a return on it, he can split the income of that trust between himself and the 2 children, which, as you pointed out, the tax benefits of a testamentary trust are really great because you do have the ability to split the trust income between a class of beneficiaries, particularly when you've got minor children. Their distributions to them from a trust are taxed as if it's regular adult income, which means the current income-free threshold, I think, is about $18,200. So every year, Ben can say, okay, I'm on a good income, but we've earned $40,000 this year from the assets in this trust that my wife Amy left us when she died. I'm going to split that income between my 2 kids. I can use that income to pay for their school fees, and it means the tax implication is minimal compared to if Ben had invested those assets in his own name and he was just getting that extra 40 grand whacked on to his own tax return.
Or if when they were held by the kids, to interrupt, if the kids otherwise can earn $416 before they start paying really punitive tax rates. So just that differential there makes a huge difference. Yeah,
absolutely. So then if Ben also dies and the kids are still young, that trust is going to keep going for them. We would also set up Ben's will as a mirror, so his assets can go into the one trust, and so it makes it just easier administration. There'll be one trust going forward for the benefit of the 2 kids.
Oh, okay. Sorry.
Yeah.
So his assets, if he's accumulated future assets over the intervening 10 years, that can drop back into the same trust?
Yes, absolutely.
Oh, cool.
Yeah. It just makes that much easier from an administration perspective. There's just one trust going forward. And so then Fiona's going to step in. She'll be the trustee of that trust. She'll be looking after those assets for, let's say, they're her niece and nephew. So she'll be investing them year on year and every year making distributions. And that can include distributions to Steve for, again, those sort of child rearing expenses like school fees, food, accommodation, all the basics. When the kids are a bit older, Steve will step out of the picture once they're over 18. And we usually set a certain age that the kids can start to have more involvement in the trust. They can become trustees themselves. They can access more of the capital. But we try and keep that bucket sort of intact as much as possible for going forward for the asset protection.
And what's a common age that people are setting their testamentary trust to pass on to the beneficiaries of it?
We usually like to say, as a guide, and again, this is really subjective, it depends on individuals, but we like to say about 25 as an age where the kids can start to act as trustees. We might say that when they're both over 30, that's when they can act without, say, their aunt or uncle's involvement, and they can just run it themselves. We also like to say that the kids can't receive distributions of capital until they're 25, unless the trustee says you need some for your maintenance, upkeep, your well-being. Only after kids get to a certain age, they can say, I would like to take a big chunk of capital out of this trust. But again, that's not something we sort of recommend because the whole point of the trust is to keep everything really protected. So what we would say is that, say, if I was the beneficiary of a testamentary trust, and I wanted to purchase a house with my partner, instead of saying to my aunt or uncle who's the trustee, can I please have $500,000? Thank you, and taking it with me, I would enter into a loan with the trust. So I would borrow an amount of money from the trust. There would be a proper loan agreement documented. If I was buying the house with my partner and we were both going to be on the title to the house, we should both also be on the loan agreement. We sign off on that. Then if something goes wrong, my partner and I separate, or he's sued in the course of his business, the testamentary trust is a creditor that needs to be repaid. Those assets go back to the trust and they stay protected. That chunk of money isn't coming out to then be scrambled up with my partner's assets and then potentially become lost. The idea is that for years going forward, as much as possible, the capital is nice and tied up in this little pot. Beneficiaries can still access it as needed, with larger chunks through loans or smaller distributions as they need it. But again, just trying to preserve this pot as much as possible.
I think it's a really important distinction, and it's a really good point that these things, like anything in estate planning, they're not a fixed document. You should be working with your advisors on an ongoing basis to make sure you're optimising and making the most of the benefits that come with a testamentary trust. Just quick, I mean, we've talked about the positives of a testamentary trust. Are there some negatives that kind of come to mind when you talk about them?
Yeah, I mean, I would say there aren't too many negatives, but there are a couple of things to keep in mind when you're deciding whether it's right for you. So firstly, to set up a testamentary trust requires a more complex will than you would have otherwise. So sometimes if people don't have a lot of assets, their advisor might say, look, for the cost of setting this up, it might not be worth it for you, because you're looking at maybe paying 2 or 3 times as much for a will as you would for a more simple will. There is also an ongoing cost every year, and we'll talk a bit more about the ongoing obligations later, but every year there does need to be a tax return put in, so you'll need to engage an accountant. So that's sort of a bit of an ongoing cost. And the other thing is that testamentary trusts are really great when your beneficiaries are in Australia. We do have a lot of clients who have beneficiaries who live overseas, and it might not be practical for them to have their assets sitting in an account in Australia. There might be tax implications of sort of foreign beneficiary, foreign trustee laws, and it might be that where they're living overseas, there's not sort of an option to have an equivalent structure over there with the same protection. So sometimes if you have a beneficiary who is going to reside long term in the States, for example, it might be easier for them to just receive their inheritance as a lump sum, so they can put it in their account in the US and deal with it there.
And you mentioned earlier that all of this is very subjective, and it's very contextual, obviously. Like, it really does matter on the lawyer and the advisors knowing the client sufficiently to be able to draft a really bespoke document, which is where the value is, I imagine. Like, that's why you engage somebody to do this. It's not a post office will that we're talking about here.
Absolutely. And that's something that so when someone calls our office and says, how do I make a will? How much is a will? What do I do? We say, come in, sit down. We need to chat to you. We need to figure out where, the lay of the land, where your assets are, who owns them, and what you actually need to create something that's quite bespoke and personal. It's not just a ticker box sort of situation.
And so I think I'm curious as well. You mentioned the testamentary trust is one that comes into force through a will when somebody dies. So I'm curious, what are the steps that occur when somebody actually dies from the testamentary trust perspective? So, for instance, when does the actual instrument come into effect?
Yeah, so what we would usually say is we have this initial period of administering the estate. As we talked about before, the role of the executor calling in the assets. When that administration is done, and the asset pool is sitting there, that's when it rolls into the trust. So that's the point in time when the trust really comes into effect. And the actual mechanics to set up the trust are actually quite simple, because all the hard work has sort of been done in the will. All that really needs to be done to get that trust rolling is to have the assets in the name of the trust. So what would happen is we'd have an estate bank account that's used while we're managing the estate. It pays off any expenses, anything that's sold, the car, any property, any shares. Those proceeds will sit in this estate bank account. Once all the administration's done, we then say, okay, we're rolling all these into a bank account in the name of the trust. So the Bob Jones Will Trust account, and that sits there. And that's really when the trust starts to work. Yep. Same thing with property titles. So to be held by the trust, the property needs to be in the name of the trustee. Interestingly, on the actual property title, it doesn't say the name of the trust. It usually just says the name of the trustee. So if Fiona Jones is the trustee for the Ben Jones Testamentary Trust, the title to that property will just say Fiona Jones, but the trustee sort of sits behind that.
And it'd be the same with shares and any other assets that aren't to be cashed out. They need to have their ownership transferred to the name of the trust.
Yes. So share registries usually either transferred into the name of the estate. Sometimes the share registries let you put the name of the estate on it, or otherwise just into the name of the trustee.
This is probably a bit of a silly or random question, but do you ever come across a trustee that wasn't aware they were to be the trustee and sort of thrust upon them?
Sort of. I've had situations where people have known that they're an executor of a will. They've been told that, but they haven't sort of been given an overview that there's going to be a trust or what those trusts entail. And yeah, definitely, people can be quite taken aback, especially I've had situations where people knew they were going to be an executor, but they didn't realise that the will created 4 separate testamentary trusts, and they were going to be trustees of all of them. And so that can be quite a surprise. And I would say that, during the lifetime of a will maker, there's no obligation to tell anyone what's in your will. You absolutely don't have to. It's not like, for example, a power of attorney where you need to get someone to sign to agree that they're going to be your attorney. No one needs to sign anything to agree to be your executor or your trustee, but I definitely think it is worth having that conversation. We actually sometimes have meetings with the children who are often also the trustees of our clients. Just say, come in, we'll do a little diagram for you and just show you how it's all going to work and explain to you some of the benefits that we've chatted about so far and some of your obligations, because it absolutely can be a shock and it can be quite overwhelming. And people say, I had no idea that Dad did this. And sometimes they don't understand the reasoning why. And it's already a very stressful time when a person dies and you're an executor, and having that sort of extra confusion and surprise is not particularly helpful at that time.
And this is probably a very big question, so feel free to sort of prune it down as you see fit. But what happens if there's a dispute to the will and there's a testamentary trust there as well?
Yeah, so in terms of disputes to the will, generally the time frame for bringing forward a claim for what we call further provision is 6 months. So there's a class of people in the Administration and Probate Act who are eligible persons to make a claim for further provision from the will. So it's someone who's either been excluded completely or they've received something and they don't think it's enough. And they fit into these categories, which is defined by their relationship to the deceased. So children, spouses, members of the household, and then sort of a wider class of people who might have been dependent on the deceased. They have the ability to make a claim if there are grounds, and a lawyer needs to advise them about that and sign off saying, yes, I think they have a proper basis to make a claim. But generally they have a 6-month period in which to bring that claim. What we say then to our executors is, we're not going to distribute the estate and we're not going to roll into that new trust phase until that 6 months is up. If someone does come forward in that 6 months to make a claim, the sort of ongoing administration of the estate is put on hold a bit, because you have to just keep those assets sort of as intact as possible in case, because you don't know what the payout to that claimant is going to be. But there might be circumstances if someone has a real need that they might be able to apply to the court and get a little bit of money out of the estate in the interim. But generally that dispute just sort of puts everything on hold for however long it takes to resolve it. And
I think it's good to have those defined timeframes, I imagine, because you don't want it dribbling on forever, but you also don't want to act prematurely either. So it just sits on hold, and you kind of let it play out. The process is maybe distasteful as it can be sometimes along the way. Which leads me into kind of the third area I wanted to talk about testamentary trusts. And obviously the audience for this podcast are people that are financially inexperienced in the first 3 years of sort of the loss of their partner, and now they're managing things, and they might be in that bracket of people who have kind of been surprised that they're now trustees and what's involved. So I'm curious to walk through those, I guess, day by day or annual obligations. What are some of the annual obligations you have as a trustee of a testamentary trust?
Yeah. So the first one is the tax standpoint. So the trust needs to file a tax return every year for its income. And what we also would say is that every year you should sit down with your accountant and talk about how you're going to allocate the income of the trust. So every year the trust will earn a certain amount from return on shares or rental income on investment properties or interest on interest-bearing accounts. If the trust holds on to any of that income, it is taxed very highly and it's not sort of recommended at all. The idea is that every year we want to be dividing that income between the beneficiaries. So it's good to sit down with the accountant because they will be able to say, look at all the beneficiaries and say, where's the most effective way we can allocate the income from a tax perspective? We talked about before, minor children, they can receive their $18,200 each year, provided they're not, 15-year-olds who also have a part-time job, because that'll be a little bit different. But we look at beneficiaries who can receive income tax-free, and then we might look at whoever else is included in the class of beneficiaries. And you also want to be thinking too about who might need a little bit more that year. For example, you might say, okay, I've got some grandchildren in my 20s, they're beneficiaries of the trust. Last year, Matt got an extra distribution of income so he could buy a car. This year, Kate's going to get a little bit extra so she can buy a car, those sorts of things. So the tax return and the splitting of income on an annual basis is something that's really important. And I think having an accountant that you trust is really important from that perspective to sit down and do.
Proactive too, so you can have that conversation in April, May, June, rather than last minute trying to rush it through.
Yeah.
And this is pretty elementary as well, but the costs for that are borne by the trust, aren't they? The trustee is not expected to pay that out of pocket.
No. Any expenses relating to the administration of the trust, so including accountant's fees, and also if you're engaging a financial advisor for the trust, which is, again, something that we really recommend, again, those fees can be paid from the estate. So as a trustee, you actually have a duty under the Trustees Act to review your trust's investments every year and make sure that they're still performing well. I mean, you don't have to be an expert, and we don't expect trustees to be, naturally amazing at investment and, be looking at things that are making crazy returns. But we just want to make sure there's some ongoing review and ongoing advice. So again, on an annual basis, we'd recommend sitting down with a financial advisor for the trust, just having a look and saying, here's where we are at the moment. Do we want to make any changes? And listening to their advice.
And is there an audit obligation for the trust itself?
I think that the trusts can be audited. To my knowledge, it's random, but I'm not 100% sure.
Yeah, so it's not like a self-managed super fund where you have to have that annual audit done. It's just keep your books in order, stay up to date. And I think you mentioned earlier, the expectation isn't that you're an investment expert or a cash or money expert, but you need to be organised. You need to have your stuff maintained, because there's a lot that's required on a documentation level, if nothing else.
Yeah, absolutely.
And is there anything else that kind of is really should be part of that calendar across the year?
I think they're the main ones.
Yeah, it makes sense. I mean, it's not nothing, but it's not super onerous, I think, if you've got good support and good advice around you.
No, absolutely. I think that's really something that's really key, is having that good support and advice. In the early stages of the sort of administration, you might want to be you would want to be chatting to the will maker's accountant and financial advisor to get that idea of where they were at. There might also be, final tax returns that need to be filed for the deceased, those sorts of things. But you don't have to stick with those people either. I mean, I think it's really important having a financial advisor that you trust and that you're comfortable with, and that they can be someone, because as I said earlier, the trust can continue for 80 years. So you want to have someone that you're happy to have that chat with every year, because it might be for a long time.
It's a big consideration, and particularly with that mismatch sometimes between experience and knowledge, different advisors speak to different points and different methods. So yeah, absolutely find the person that's a good fit for you. With the trustee work, can trustees be paid for the work they're doing in administering the trust?
Yes.
By the trust itself?
Yes, they can be. So there's a couple of different avenues that can take. The will might say that the trustee is entitled to be paid for their pains and troubles on a regular basis. There might also be a percentage or a fixed fee gift that's made to them to cover that expenses. Certainly if you're someone who's engaging a professional trustee, which is something we haven't talked about much so far, but sometimes a will maker may decide to, rather than giving the role of trustee to a family member or a friend, they might engage a trustee company. There's a few around Melbourne, or Australia more generally, that they might engage, or they might ask, for example, their accountant or financial advisor. In some situations, and this also depends on their license as well, they might ask them to be the trustee of the trust. Certainly, most wills would have a clause that allow those professionals to be paid their usual hourly rate. But in terms of just appointing a friend or a family member, not every trust will have, or every will have a clause allowing them to be paid.
Mm-hmm.
Sometimes, if the trustee is also a beneficiary, it's sort of a bit like, well, you're getting a benefit of the will, we just expect you to do it. But there are also avenues that you can apply to the court for payment as well.
Yeah, okay.
Or you can ask the beneficiaries to agree. That's another option.
Oh, that makes sense. Is there an obligation for trustees, I guess not because they're often minors, but to meet with the beneficiaries on an annual basis or anything like that?
I wouldn't say an obligation to meet with them on an annual basis, but you do have an obligation to keep good records. And if a beneficiary wants to see the records and they want to chat to you about it, that is something that you need to do, yeah.
Yeah, right. Yeah, okay.
We
so
would
you need
say
to provide
that,
them.
yeah, if a beneficiary requests the records, you do need to provide them. We would also say that transparency is really great. I mean, as you're saying, you might have minor children, but as they get older, we would definitely encourage people to be really open about the mechanics of the trust. It just makes it easier for everyone. As a trustee, another sort of important thing to remember is that most of the trusts that we were talking about are discretionary trusts. So we have a number of beneficiaries and you make a decision each year as to how income or capital is allocated. And that will depend a lot on taxation advice, but you can't have just a fixed policy in place. You can't, what they call, fetter your discretion and either leave it all to the accountant and say, you decide. And you can't say, right, every year we're giving a third, a third, a third. That's it. Oh. You actually do have a duty to exercise your discretion. And it may be that it ends up being a third, a third, a third. But you do have to consider the different beneficiaries and think about who might need more money. Again, it's not that you have to make a certain decision a certain way. But the main thing that the court doesn't want is that people really go hands off with it and just say, here's my flat policy. I'm not taking any other considerations into account. I'm just sort of walking away.
Which makes sense at, I think, a conceptual level, but that level of detail is really interesting. So the trustee's there to act in the best interest of all of the beneficiaries, not them as a homogenous group, but individually, and consider it and record that, I assume. So you've got some information there. I can't remember the case now, but I heard of a matter recently where it was a self-managed super fund, and the member died and it passed through to the trustee. But the court, one of the reasons the court found against the trustee in this action is they weren't familiar with their duties under the Trustees Act. So I assume then that is something that people should familiarise themselves with, is just what their duties are, because they are pretty fulsome. Yes,
yeah. And it can be difficult too, because for a trustee, there's duties that are in the Trustee Act, and there's also duties that are sort of common law duties that aren't necessarily recorded in legislation. And, this is something that people spend a whole semester studying at university. It's not like it's necessarily, easy.
Yeah.
That being said, there is a lot of information online, and your solicitor can provide you with a bit of an overview. But yeah, some of those duties are the ones we've already talked about. So exercising discretion, acting in the best interests of beneficiaries, reviewing investments on an annual basis, taking advice, which I think is a really important reminder, as we've said as well. But again, plays into that idea that you don't have to be the expert, but you need to listen to the experts. Other sort of ones that are in the Trustee Act are not to invest in things that are speculative. You can't really go wild with your investment ideas. You need to have a sort of a solid plan in place. Making sure you comply with the deed. So in this case, the deed is the will. So making sure you're sort of familiar with that. If you've got any questions, take the will in to your lawyer and get them to go through it with you. That's always a good idea. And another one is just maintaining the trust property. So generally we'll say in our wills that if the assets of the trust diminish through no fault of your own, the market crashes and suddenly a house isn't worth what it's worth, that's fine. That's no obligation on you because you can't control those sort of market forces. But for properties in the trust, you've got to sort of keep them in good order. So residential properties, you can't let them just fall into absolute disrepair. And in terms of the sort of other assets like the shares and securities, that's something where that ongoing review is important, just to make sure that you aren't letting assets be wasted just due to your neglect.
And I think
it's got to be sort of an ongoing role.
I think to that point around that, and also the advice piece, I think it's fair to say that if you feel like you're doing it alone, then you need a different advisory team, because I think you should be able to work with all the people that are involved, from solicitors, accountants, and advisors. Like you say, take the will into the solicitor and confirm things. Like that should be part of the team dynamic that you're working with, which brings me around to, I guess, my last question is, from what you've seen and in your experience, how can things go wrong with a testamentary trust? What are some things people should avoid?
Yeah, I think the main sort of things that can go wrong is where a trustee isn't sort of meeting those obligations. So failing to file the tax returns every year obviously is a big no-no, because those will pile up and it will become really complicated to sort out afterwards. Something that can sort of go wrong is just the interpersonal side. So it can be difficult dealing with the relationships between the trustee and the beneficiary, particularly if you've got a situation where there's been a trust created to sort of protect someone from themselves. That might get a bit difficult between them and the trustee. What I would say in that sort of scenario is, again, relying on the professionals around you. If relationships are starting to break down between the trustee and the beneficiaries, engage a solicitor, get someone to do that sort of correspondence piece for you, so you're not handling it by yourself. Down the track, if things escalate, there are options for sort of mediation and those sort of issues, but we want to avoid that happening. We want to keep everything really calm and professional. If you're a beneficiary of the trust and the trustee is really failing to meet their duties, so not filing tax returns, not being transparent with bookkeeping, making poor investments, those sorts of things, there are legal options that you do have to seek to have that person removed. And in those cases, you might want to appoint a professional person in their stead to sort of sort things out. So that is something that can happen.
Thank you, Claire. It's just so interesting and such a fascinating area of law, which I imagine is why you're specialising in it. I think we've barely scratched the surface of everything. As you mentioned, this is what people study semesters or even years at university about. So we've kind of barely scratched the surface. But hopefully it's been useful for people that are going through this process and inheriting that mantle now of managing the assets to understand that it's a serious duty, but it doesn't necessarily need to be an onerous one. Just you need to be very mature and serious about it. What I would say is people will probably have questions about this, Claire. Where's the best place for them to reach you if they do have questions or they wanted to have a chat?
Yeah, so I would say sending me an email is usually the best way. So if you search Tony Kelly Lawyer, you will find our details there, or my email address is just cs@tonykellylawyer.com.au. We're also available on the phone for people to come and have a chat. Always happy to have a sort of no obligation meeting with people who've got questions, and if we can help, we can help, and if we can't, we can refer you to someone who can. So that's sort of our approach.
Which I think is a great approach. It's one that I think good professionals all share. I would, as a final word, just say this is a very detailed, as you can tell, a very expert area. So engage an expert that has that experience and that depth of knowledge around this, because things can go wrong or things can go very well, and you don't want to be at the wrong end. Thank you again for listening to this episode of Life, Loss and Legacy. If you do have any questions for Claire, be sure to send her an email, or you can email me at jordan@planningsolo.com.au. Thanks for listening, and we'll see you next time.